Hello, my name is Mesha Mainor. I am the state representative for Atlanta, Georgia. I pray my service to Georgia is received as an opportunity. My responsibility is to secure the Georgia budget and create legislation that is impactful. Today and all days, our priority as U.S. citizens must be fair elections. Your voice at the ballot is your way to actively engage your leaders. My job is to do the research and fix the problems within the Constitution for you and our families. I want to start my first term by giving you some basics, the ethics in elections. The governing pioneers of America created the Constitution and this ideal of inalienable rights. We, the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity. Do ordain and establish this Constitution for the United States of America. In this presentation, I'll give an extensive history of the disenfranchisement in the U.S. and Georgia and the bloody price for equality. The remainder of this research analyzes legislation and ethicality towards blacks, black voting rights pre and post the civil rights era, the 2020 elections in Georgia, Fulton County election leadership and ethics, the chain of command in Georgia elections, the oath of office and its protection of the U.S. and Georgia constitutions, conflicts of interest between government authorities and marginalized citizens, disenfranchisement of the black vote, consequential outcomes of unethical behavior and its impact on stakeholders. And last, I give some recommendations for the Georgia State Board of Elections and other vested parties to consider a new realm of understanding and a perspective when considering voter suppression, disenfranchisement, and voting rights, in addition to election law rules and regulations. Georgia was established in 1732 as a haven for the indebted of Britain and Christian reformers. James Oglethorpe envisioned Georgia to be a place of second chances. It banned slavery, but the original colonists complained that slavery was found to be their only option to be profitable. Georgia was the largest state in the South and eventually was home to the largest number of slave plantations in the South. During the antebellum era, Georgia was dependent on the trade of black humans for its economic prosperity. It embodied Confederate ideals and refused to grant blacks freedom, justice, and the right to vote, even when mandated by federal laws. As the most southern state of the first colonies in America, Georgia became known for its unconstitutionality practiced on the marginalized, refusing them rights with qualifiers like wealth, race, gender, and ethnicity. After the Emancipation Proclamation in 1863, blacks were granted freedom and inalienable rights like voting. Initially, only white men that were landowners could vote. The Constitution did not afford white men without land, slaves, blacks, the indigenous, or women the right to vote. During this time, known as the Reconstruction era, blacks were given a window of opportunity that their oppressors just hadn't anticipated. 130 years after Georgia was founded, ex-slaves elevated themselves to equal footing with white men when 3 blacks were elected to the Georgia General Assembly. Georgia was the only state to have black men on the ballot. These truths forever set Georgia apart from the rest of the nation. Now let's go back 100 years prior. In 1755, Georgia's first legislators voted to make slavery legal, stripping the original slavery ban from its founding charter in 1732. It took 20 years from Georgia's founding when its first leaders decided they could not survive and compete in the New World without sacrificing Black lives. They needed Blacks to survive. By 1828, all southern U.S. states realized slavery equaled money, while the northern states advocated against slavery. The Jacksonian era created this universal white male suffrage movement, which granted white men without land new rights to vote. These laws continued to oppress women and minorities. The Jacksonian era tactics divided the nation into the Democratic Party and the Republican Party. The Southern Democrats vied to oppress blacks, while the Northern Republicans advocated abolishing slavery and mandating equal voting rights for all U.S. citizens. In 1861, Georgia seceded from the Union, entering into the Civil War to fight for the business of slavery. On January 1, 1863, President Abraham Lincoln issued the Emancipation Proclamation ending slavery in the United States. The proclamation granted blacks freedom from their bondage, but not equal citizenship or suffrage rights. In 1870, the 15th Amendment of the Constitution gave persons the right to vote regardless of race or color. 50 years later, in 1920, the 19th Amendment gave women the right to vote, but Georgia withheld a woman's right to vote until 1970. Approximately 120,000 soldiers from Georgia fought for the Confederate Army to save slavery and oppress blacks. Nearly 3,500 black men left their families in Georgia to fight for the Union Army and their rights. 3 million soldiers fought in the Civil War, the real first battle for Black Lives Matter. Almost 800,000 soldiers died for the price of slavery versus humanity. 1 out of every 10 white men were killed. In 1865, after the Union won, President Lincoln was assassinated for abolishing slavery. Frederick Douglass said slavery is not abolished until the black man has the right to vote. In 1866 and 1867, Congress rejected 2 of President Andrew Johnson's vetoes to pass the Civil Rights Bill and the Reconstruction Act, but for the first time in American history, legislation became law without a president's approval. During the Reconstruction era after the Civil War, the U.S. Freedmen's Bureau in Georgia galvanized black voters, educating them about their rights and advocating for blacks to run for office. In 1868, the Freedmen's Bureau helped get the first black men elected in American history. America and Georgia's first black members of an elected office were Aaron Bradley, Tunis Campbell Sr., and George Wallace. They served in the 80th General Assembly. 3 legislators were elected in July 1868. Still, fellow lawmakers expelled them 2 months later in September, stating, "The state constitution does not recognize the rights of black citizens to hold public office, making them ineligible to sit in the Georgia General Assembly." The original 33 where men positions were restored at the end of their term in the 1869 White versus Clements Supreme Court ruling, which stated that blacks have the right to hold office. The law was later enacted as the Civil Rights Act or the Force Act in 1875. The act was sponsored by U.S. House Representative Benjamin Butler and U.S. Senator Charles Sumner, both from Massachusetts. It was co-written by U.S. House Representatives of Virginia, John Mercer Langston, who was also the first dean of Howard University's law school during the 41st Congress of the United States. In 1870, the first blacks, 30 members in total, were elected into the 41st Congress, including Representative Jefferson Franklin Long of Georgia. Each newly elected black leader was a Republican with pro-union ideologies that supported equal rights. As a result of Georgian Democrats' opposition not accepting the newly elected black legislators, General Terry of the Georgia 3rd Militia purged Democrat Confederates after the black legislators were reinstated. General Terry replaced the Confederate members with their Republican runner-ups, giving the General Assembly a subsequent majority rule by the Republican Party. This allowed the 15th Amendment to become law in 1870, which ultimately gave blacks the right to vote. Later in 1870, Georgia's new elections were won by a Democratic Party majority win. The Democratic Party was known during these times as the Redeemers and also the base for the Ku Klux Klan. They enacted new laws called the Black Codes, which accelerated disenfranchisement and the marginalization of blacks. William Rogers, the last African American to serve as a member of the Georgia General Assembly after the Reconstruction era in 1907, resigned in protest of this disenfranchisement, saying, "Negro and white people of Atlanta and the South must alter the lines which have divided them. There must be a policy change. A new generation is coming upon the stage of action in the South. They know little or nothing of the regulations or the horrors of the past regime, and they question the right of their equals to oppose and defraud them." 25% of the black elected officials were killed, threatened, beaten, or jailed during this time. While the price of blacks' freedom and their rights for equal citizenship was paid for during the Civil War with American blood, 3 years later, after Representative Rogers' plea, President Theodore Roosevelt stated in a 1910 speech, "We should not take part in acting a lie any more than in telling one. We should not say that men are equal when they are not equal, nor proceed upon the assumption that there is an equality when it just doesn't exist. But we should strive to bring about a measurable equality, at least to the extent of preventing the inequality." The authors of the Declaration of Independence intended to include all men, but they did not mean to declare all men equal in all respects. They defined with tolerable distinctness in what they did consider all men created equal, equal in certain alienable rights, among which are life, liberty, and the pursuit of happiness. President Roosevelt went on to say, "They did not mean to assert the obvious untruth that all were actually enjoying equality, or yet that they were about to confer it immediately upon them. They meant to set up a standard maxim for free society, which should be familiar to all, constantly looked to, constantly labored for, and, even though never perfectly attained, constantly approximated, and thereby constantly spreading and deepening its influences." He said, "Augmenting the happiness and value of life to all people everywhere. We as Americans are bound in honor to refuse to listen to those men who would make us desist from the effort to do away with the inequality, which means injustice, the inequality of right, opportunity of privilege, we are bound in honor to strive to bring even nearer the day when, as far as humanly possible, we shall be able to realize the ideal that each man shall have an equal opportunity. In 1898, disenfranchisement became legal in Georgia. Georgia lawmakers began to oppress black votes informally with state legislation. In 1917, the Neal Primary Act enabled the Georgia lawmakers to use an electoral system that allocated votes by the county's population size during primary elections. The new law determined that candidates could only get elected with the majority unit voted system versus a popular vote. The Neal Primary Act allowed white males to control the Democrat and Republican parties, regardless of which Democrat or demographic dominated that particular county. The Neal Primary Act disproportionately allocated significantly more votes to low-populated communities in the rural South, while decreasing the allocated votes in more populated urban counties like Fulton, where most black voters lived. Georgia categorized its 159 counties by its population size. Under the new legislation, black highly populated urban counties were only allotted 8-unit votes. Within each categorized county, votes were distributed as unit votes. Rural towns were given 30, farm countries 121, and for a total of 410 unit votes, urban blacks received 6 units per vote. Towns received 4, and rural counties received 2. To be elected, candidates needed 206 unit votes during a primary election, despite the popular vote, meaning despite a majority win. The county unit vote system allowed rural white counties to disproportionately control 59% of the votes, although these counties only accounted for 32% of the population. For example, 3 rural counties with 5,000 votes were allowed 3 unit votes, while black counties with 500,000 votes were allotted only 1 unit vote. Known as black codes because they suppress blacks, Georgia laws indignified blacks as products for the sole purpose of white male commerce. These egregious laws further marginalized blacks from opportunities of civil, social, or financial privilege, including the right to vote. The black codes intentionally favored Southern white voices over black, indigenous, and women voices. Legislators in Georgia used creative language to leverage suffrage with literacy tests and poll taxes. When voting rights were granted to blacks, the Jim Crow laws were enacted to force legal segregation between 1870 and 1950. Jim Crow laws imposed legal punishments on people for consorting with members of another race. Jim Crow laws and the Neal Primary Act were Georgia's retaliation to losing the Civil War. Georgia would act in defense mode for another 150 years and counting. As the foundation of inequality for blacks, marginalized communities still experience disenfranchisement, lack of opportunities, and segregated resources for education, housing, policing, and reentry citizenship. According to Grant, requirements for blacks, ex-slaves, or slave descendants to register to vote as the state constitution mandated were exhaustive and unfathomable to pass. Blacks were required to pass these literacy tests with little to no education when available in front of the very people who advocated for them to remain slaves at these election boards. while most whites were exempt, or they had to pay to vote with little to no income because they were ex-slaves. To decrease the effect of Jim Crow laws, the 1962 Supreme Court abolished the county unit vote system as unconstitutional in Baker v. Carr and Gray v. Sanders case in Georgia, stating all citizens' votes should have the equal weight of one man, one vote. The new law has become informally known as one man, one vote. In 1965, the Voting Rights Act was passed. The Motor Voter Act was passed in 1993. Both laws help decrease voter suppression, but election reform is still needed in counties like Fulton. The Georgia Budget and Policy Institute states Black Georgians have made monumental progress despite the machinery of white supremacist culture, politics, and law. Yet the impact of Black codes is still present in 2020 and continues to suppress the Black vote. Georgia is trying to climb its way out of an unethical infrastructure built 300 years ago. Today, most citizens over the age of 18 have the right to vote, but many believe a Black person's right to vote is still infringed. And COVID-19 is testing Georgia's infrastructure once again, similar to the Civil War. As more people vote, there are unfortunately more opportunities to suppress the votes of the marginalized. Georgia's living standards, ideologies, and the uprising of political citizenship are changing society and communities. As political tides shift, persons registered to vote can receive an absentee ballot by mail. Children are learning from home. Americans are wearing masks to protect themselves in public. Businesses are rethinking their strategic operations for new paradigms of commerce. And social awareness has strengthened the voices of advocates that fight for racial equality, human rights, police brutality, and voting. The 2020 elections are unprecedented with a surge of political activism, rioting, peaceful protests for civil liberties, and ideals envisioned by Democrats and Republicans. The continued unrest surrounding President Trump's win over Hillary Clinton in 2016 has also increased. Like the Black codes, former Secretary of State Hillary Clinton won the popular vote. Still, President Trump won the electoral vote, similar to the county unit vote system. Voters from both Democrat and Republican parties are questioning aspects of President Trump's leadership, even attempting to impeach him as the United States' 45th president. The challenges facing the Trump administration have contributed to a massive early voting turnout, especially in Georgia. Georgia is making history with nearly 600,000 more registered voters in 2020 than in 2018. The current factors at the forefront for many voters are the imminent dangers of race riots, COVID-19, volatile unemployment rates, African Americans disproportionately affected by public displays of police violence and killings, natural phenomena. We've had killer bees and transnational dust storms this year, as well as now the COVID-19 vaccine development and the execution of its delivery. COVID-19 has shown leaders worldwide the importance of disaster planning and emergency preparedness. But preparedness planning should not exclude election management. Although Fulton County is the biggest county in Georgia, it shouldn't inherently expect to have a proportionate election logistics failures. The Secretary of State, Brad Raffensperger, states Fulton is the poorest performing county in Georgia regarding election management. Its elections comprise 80% of Georgia's election complaints. Yet there is a disproportionate amount of complaints sent to the U.S. Attorney's Office for review by the Georgia Board of Elections. Every county has its priorities for operations. Fulton County appears to have significant leadership ethics failures. During these critical times, Fulton elections will succumb to its archaic operational processes or attribute steps to make itself a national election management leader. Successful election management consists of two principles that can transform election strategy: equitable election laws and progressive operations that optimize a person's right to vote. With multiple stakeholders, election leaders must be efficient, employees committed, and operational ethics at the forefront when serving the public. Ethics in elections must supersede political propaganda. The fundamental and critical element of ethical and competent leadership is fulfilling your duty to serve. It plays a significant role in securing fair elections, decreasing voter suppression, and strategizing for 21st century voting in the era of globalization. Election leaders must show evidence of competency before onboarding. Election managers are county fiduciary officers responsible to its citizens by optimizing strategic election operations. In Fulton County, Election Director Richard Barron must show county residents he's accountable to them with faithful diligence to protect their 15th Amendment right bestowed in the U.S. Constitution, and that their right to vote is without barriers in every single election. Election practices are transformative when legislation and ethics are synergistic. Ethical leaders should create an environment that involves systematizing, defending, and recommending concepts of right and wrong, complementing philosophical axiology. As election legislation and voting rights in the United States improve, Americans face this challenge in elections: malfeasance. Urban, predominantly black counties like Fulton experience poorly managed elections, which simple project management logistics could eliminate these atrocities like 13-hour wait times at the polls, unmailed absentee ballots, voter ID discrepancies, excessive vote counting backlogs, tampered vote tallies, poll worker mismanagement, poor ballot transaction management, and disinformation relayed in black communities. These are all examples of what has happened in Fulton County. The disproportionate impact of poor logistics in urban black counties during elections has caused Americans to be more critical of election logistics. The political divide between Democrats and Republicans contributes to the historic changes taking place during this time. And for the first time in history, the first African American woman was elected as Vice President of the United States of America. Additionally, the 2020 census is paving the way to potentially reshape election district lines across America, which will give black counties more power for their votes to be heard. With elected leaders under increased scrutiny and its citizens' watchful eyes, even the once not interested non-voter is watching and voting. Stacey Abrams' response to Georgia's elections was stating a disaster that was preventable, emblematic of the deep systemic issues we have here in Georgia. One of the reasons we are so insistent upon better operations is that you can have good laws, but if you have incompetent management and malfeasance, voters get hurt, and that's what we see happening in Georgia. The Fulton County Department Elections Director Richard Barron has rationalized problems in the past as equipment issues caused by different training challenges. But Georgia's ACLU Director Andrea Young says the Georgia absentee ballot problems are in part based on authorities not allocating sufficient resources to complement more voters being engaged. Further, Young states the problem is due to election officials either intentionally or indifferently failing to provide enough staffing to run an election. As state representative for District 56 in Fulton County, home to approximately 10% of Georgia's population, I see firsthand the tale of two cities, the haves and the have-nots. District 56 is Atlanta's economic hub and home to Georgia's largest percentage of Fortune 500 companies. Yet District 56, like all black counties, have a significant demarcation of resources, healthcare access, education, housing, blight, unemployment, reentry citizen rates, crime, disproportionate opportunities, and yes, voter suppression. The problems in election management in Fulton County, it's not just a Fulton problem, it's a Georgia problem. Former Georgia State Representative and House Reapportionment Chair Joe Mack Wilson once said, legislative members are more motivated by survival than concern about a colleague's problem. As much as you might want to help a person whose district is in jeopardy, a legislator must first make sure his own territory is protected. In other words, a lack of fortified unity between counties and elected officials within a state only hampers black counties from these systemic racism opportunities at the polls. Secretary of State Raffensperger reports that of Georgia's 159 counties, by and large, 150 counties have really done a great job. But it eerily points out the disproportionate election resources allocated to predominantly black counties. Secretary of State further points out we have one county that just stands out with glaring failures, and that's Fulton County, and unfortunately, that is our largest county. Fulton County is plagued with voter confusion, leadership criminality, gerrymandering, unaccountability, and a disproportionate amount of black reentry citizens unable to vote as victims of mass incarceration laws. Thus, getting things wrong leading to Election Day, on Election Day, or after Election Day is never an option. Election leaders make decisions that impact millions of people when you consider a household vote. For example, a single mom voting with 3 children has the power to speak for a total of 4 people with her one vote. Election leaders are not taking the magnitude of their decisions and management style seriously. Some argue these leaders should be held accountable and suffer penalties when they suppress votes that violate the Constitution's 15th Amendment. The list of inefficiencies in Fulton County presented in this article just highlights the need for transformative changes. Fulton County election leadership behavior and its correlation to election management gives a historical analysis of unethical leadership over the past 20 years. 2004, Georgia Board of Elections hires Sam Westmoreland as a member who later becomes the board chair. His background check was incomplete, which later showed he falsified his work history, including he never even managed an election before. In 2007, as a result of this inaccuracy in hiring, Fulton County Elections dumps more than 100,000 voter records in a trash can. 2008, there was a 53-hour backlog, which violated the state's rules with a subsequent $120,000 fine. In 2011, Fulton County Elections Director Barry Gardner, he ends up resigning after his sexual harassment scandal. In 2012, over 10,000 people were improperly registered to vote, requiring them to fill out provisional ballots. Also in 2012, 690 voters were given wrong ballots for a state Senate and House election. They missed the election certification deadline. In that September, Fulton County Elections Director Sam Westmoreland, he ended up resigning after he had 2 DUIs. That November, the Secretary of State received 111 complaints about the Elections Board, which was the highest the state had during the general election. Problems during that time: employees could not process votes due to a voter registration backlog, creating an excessive amount of paper ballots compared to other counties combined. Eligible voter lists were delivered after the polls opened, preventing voters from voting. Vote tally sheets were altered. The investigation questioned the vote totals. 9,000 people cast their ballots, but only 6,000 votes were counted. 19 precincts ran out of ballots and were not restocked for 5 hours, preventing people from voting for 5 hours. December 2012, Secretary of State reported Fulton elections with document tampering. The investigation was inconclusive, but considered it to be a mismanagement issue, even though the consequences were people being denied their right to vote. It was not sent to the U.S. Attorney's Office for further investigation. 2013, Fulton Elections Interim Director Sharon Mitchell, she sued Fulton County, stating she was fired in retaliation for whistleblowing of Fulton Elections' unethical practices. 2014, Fulton County sends more than 20,000 letters to voters directing them to the wrong polling site. 2018, Fulton Elections Director Director of Registrations and also Registered Agent for R.J. Mays Consulting, Mr. Ralph Jones Sr. He was involved in questionable business relationship with our mayor, Keisha Lance Bottoms, during her campaign for mayor. According to Fulton County Commissioner Liz Hausman, Jones's involvement with the mayor's campaign was not disclosed nor transparent, stating if we lose the integrity of our elections, we lose everything. Now, Jones's son, Ralph Jones Jr., who owned R.J. Mays Consulting, he was paid $3,600 from Keisha Lance Bottoms' campaign for unknown services. Ralph Jones' senior role at Fulton County elections entails oversight and responsibility of the Fulton County election database, the master voter list, and mailing absentee ballots to voters. Jones's son responded to the inquiry saying, "My father has no financial stake in this company. We only live together in the same house." R.J. Mays Consulting was administratively dissolved in a week. A Fulton County Commissioner, Marvin Arrington, stated, "This has left room for people to question the integrity of the process." Mayor Bottoms won that election by 821 votes. March 2019. Georgia expanded its voting system after the Kemp-Abrams gubernatorial scandal. Governor Kemp oversaw his election as the Secretary of State, also the Chief Election Officer, and the thousands of voters that were purged under his direction. The new expanded systems produced a paper ballot that voters must review for their accuracy before scanning it into a machine to count their official vote. The most recent voter suppression and ethics case involved a bipartisan board unanimously finding probable cause that Fulton County has violated election law and disenfranchised voters in the June 2020 primary election. The Board of Elections found that Fulton election leaders failed to process and send absentee ballot requests in multiple violations of Georgia law 21-2-384, section .2. Now, Richard Barron is the current Director and Chief Administrative Officer to the Georgia Board of Elections and Fulton County elections. Barron blamed COVID for the federal violation, stating an employee died of COVID-19 during the election, and COVID-19 symptoms caused another manager to be hospitalized for one day. Now, I will say further research should be conducted to get an appropriate understanding of if there were any other election departments throughout the United States that lost one employee completely, had one employee off sick for a day, to see if it compares to the disproportionate value of failures during the election, as Fulton County had. Fulton County allegations found in the Georgia election primaries included poll sites opening late, voting equipment not working, poll workers not trained, unable to manage the equipment or paper ballots, people waiting in lines for more than 3 hours, no voting equipment for people with disabilities, and there was a lack of the required voting recap sheets and provisional ballots. According to the official Georgia Code, the Secretary of State is the chairperson of the Georgia Board of Elections and the Chief State Election Officer under the Help American Vote Act of 2002 and the National Voter Registration Act of 1993. The Secretary of State is responsible for all elections throughout the state with the power, duty, and authority to manage the state's electoral system. No other official in the state has this authority except the Secretary of State. The Georgia Board of Education's constitutional duties are to obtain uniformity in every election, regardless of the county. Its election directors must implement and execute legal and pure elections that are fair, legal, and orderly. The Georgia Board of Elections has jurisdiction over Fulton County elections, and Fulton County elections is responsible for conducting elections and registering voters in Fulton County. Fulton County elections does not have separate governance from Fulton County and is governed by a fiduciary body of Fulton County, making Fulton County an egregious party in the malfeasance at the polls, which failed to protect the 15th Amendment. Separate from Fulton County elections does not have an ethics decision-making model or tool to guide its practices, an employee handbook to affirm its policies and procedures related to the Constitution, or coordinated action-driven team meetings to discuss election mishaps before or after, based on the testimony of FCE employees at an Atlanta City Council special election hearing in April 2019. In this hearing, 2 employees testified under oath that there is not a template of values or a cross-reference of protocols at their disposal. The 2 employees were Richard Barron and Ralph Smith. Fulton County election leaders allow team members to use their individual values and morals to dictate how elections are operated, according to the statement of Fulton County election employee Ralph Smith Jr., Sr., under oath in April 2019. Smith noted that there is no employee handbook for referencing his day-to-day actions while he is in charge of absentee ballots or maintaining Fulton County's master voter list. He stated he sometimes has to make up his own rules throughout the day because of the lack of governance. The impracticality of running an organization without a handbook, rules, regulations, or protocols is inherently unethical when it concerns constitutional rights like voting. For clarity and perspective, what happens if one employee decides to never return to work? How will the next person know what to do? What happens if 3 people leave? How does Fulton County train new employees without an official employee handbook for such a remarkably complex and tedious operations-based system like elections? Without specific departmental guidance, Fulton County Elections is endeavored to follow the county's overall mission to deliver efficient, high-impact service to every resident and visitor of Fulton County. The vision statement is Fulton County is a positive, diverse community with a thriving economy, safe neighborhoods, healthy residents, and a rich quality of life that all people can enjoy. It is served by a county government recognized for being innovative, effective, efficient, and trustworthy. The 6 strategic priority areas established are for all people to feel safe, have economic opportunities, be self-sufficient, trust that their government is effective, efficient, and fiscally sound, be healthy, and live culturally enriched. Richard Barron is the Chief Administrative Officer to the Georgia Board of Elections and is paid a salary by public funds to conduct elections and register voters. Fulton County Commissioners are responsible for all elected officials' payments, including the Georgia Board of Elections appointments, whom the commissioners appoint, as well as judges who oversee election laws, and the district attorney's staff. As such, more research is needed to understand any conflicts of interest between county commissioners' roles and leadership with other branches of government. For example, is it unlawful or have unethical merit if a county commissioner practices as a defense attorney against Fulton County, their employer, and possibly against the mission they take an oath to uphold? Using Fulton County's overall governance, the elections director is required to deliver efficient, high-impact elections to every Fulton County resident, create a positive and diverse community of voters and staff to help achieve a thriving economy, safe neighborhoods, healthy residents, and a rich quality of life that all people can enjoy by assisting them with voting and fair elections. Be innovative, effective, efficient, trustworthy, and fiscally sound in all duties. Deliver safe elections. Assist residents to be self-sufficient in voting. Allow voters to choose their self-selected candidates to be their chosen elected officials who will help them with economic opportunities, healthy lifestyles, and culturally enriched lives. Based on the evidence presented, not one of the previous 4 election directors of the past 20 years have significantly delivered any component of Fulton County's mission, vision, or priorities as stated, including safe elections. Merriam-Webster defines safe in this context regarding elections as free of the harm or risk or liability of unfair elections, secure from any threats of danger, harm, or loss, such as voter suppression, unlikely to produce controversy or contradiction from unfair elections, excessive needs for recounts, and trustworthy or reliable, meaning fair elections and amenable state corrective processes. These unethical leadership practices at FCE demonstrates opposition to ethicality. Ethics is a demonstration of normatively appropriate conduct through personal actions and interpersonal relationships, and the promotion of such conduct to followers through two-way communication, reinforcement, and decision-making. Unethical behaviors are acts that are harmful to others and are illegal or morally unacceptable to the larger community. The Secretary of State is responsible for managing Fulton election oversight and is positioned to positively influence pro-social behaviors throughout Georgia counties using the modeling and social learning theory. Using social learning theories, the Secretary of State can institutionally change the ethicality of county elections throughout Georgia and its subsequent workplace culture with organizational citizenship behaviors. Social learning influences can positively impact workplace ethics and group level altruism. Ethics and leadership are co-collaborators for success within organizations. Fulton County requires both to achieve its constitutional mandate of public service. Good leaders are good servants, and good servants cater to those in need of the services offered. As a public entity, Fulton Elections is mandated to serve voters guided by the law, and each employee's oath to the Constitution must be upheld. At a minimum, productive organizations should be honest, respectful, ethical, and fair to humanity. Any compromise of any workplace value only compounds current systemic failures, as we see in Fulton. If we take governance, personality, and past unethical behaviors away, Fulton Elections' duty of service is its constitutional priority. Social contract theory states that productive organizations have multiple stakeholders in which it serves. Fulton stakeholders are voters, employees, community partnerships, cross-governmental relationships, itself as a public entity, and the Constitution. Arguably, Fulton Elections should have a separate and complementary mission, vision, and values to Fulton County to effectively execute its specific duties. The leadership team and employees need readily identifiable rules and regulations, a firm understanding of its purpose, and clear role identification as servants of the public good and public trust. Immorality, mismanagement, or unethical behavior are all terms that one may use to describe Fulton election practices. Yet, ethical behavior is not a collective value system that evaluates an individual's actions as moral or not. Organizational ethics is comparable to a moral philosophy that is measured by the 12 determinants or ideologies that you see here. There's organization, which is an understanding that an organization's best interests are its complete truths. Sympathy, understanding who your primary stakeholders are and who is the priority. The science, understanding the science of the ideology. There are inversions, which is understanding that organizations are not unethical, but individuals are. Consciousness, which is an understanding of decision making based on unconsciousness. Ideology, which involves an individual's judgment and integrity. There are falsehoods, understanding that it's based on unrealistic and unbiased assumptions or excessive truths that can misguide stakeholders. Mystification, the understanding that the elite-driven ideology does exist, which inherently can involve risk and benefits of the truth. There's interest-based, which is an understanding of the organization's interests above other stakeholders and it being favored and used to dominate, such as in disenfranchisement. It's called rate basing, baiting, voter suppression, or gerrymandering. Then there's status quo, the understanding that maintaining the ideology of the current order negates voices to speak against its reality. Defensiveness, understanding that deflection supports an organization's perspective above others to protect the strong against the weak. Well-being, understanding that organizations dehumanize employees for the sole purpose to maximize profits or obtain desired business goals. And then there's history. The understanding of the present-day status quo is not influenced by historical ideals. So let's talk about consequentialism and utilitarianism as different types of normative ethics that postulate good behaviors that produce good results. Consequences determine the ethicality of actions, more so if the consequence benefits others and can be directly proportional to the number of people positively affected. On the other hand, formalism and utilitarianism ethics is a government agreement of ethical accountability that seeks to serve the public's greater good at large. Is there a desire by Fulton County to do the right thing? Does Fulton County care about the consequences of bearing an oath of office, which specifically protects the 15th Amendment? Is it criminal to not abide by the oath of office that gives Americans their most fundamental right to vote? Organizations that use the 12-point determinant test of moral philosophy to analyze its ethical character must understand that employee ethics is separate from organization ethics. Individual morality or immorality does not characterize an organization's decision-making processes or its workplace culture. Therefore, if Fulton uses the 12 determinants in their organizational processes and workplace culture, the following inferences can be made. 1. Fulton Elections is not the primary stakeholder. Fulton residents are. Fulton Elections must sympathize with current and future primary stakeholders above all others. They must use science and data to guide its operations. They are mandated to uphold the Constitution as government employees. As humans and team members, there's an understanding that there is an unconsciousness-led decision-making process. They must also not mislead Fulton County residents with unrealistic, biased, or unethical data, as we'll present later in the dashboard section. Fulton Elections cannot execute elections without a risk assessment benefit analysis. They must balance its infrastructure dynamics, avoiding authoritarian practices that can lead to disenfranchisement, race baiting, gerrymandering, and voter suppression. They must also realize the status quo is not working, and they need an immediate overhaul for democracy to ensue. FCE elections must learn offensive leadership, avoiding deflective behaviors. Teams should be diverse, inclusive, socially responsible, as well as being healthy for their success. And the history is its past. It's a legacy that Fulton County should not be proud of, and it should not be a future model. The interactionist perspective shows Fulton Elections leadership qualities compared to leadership personality traits using an ethical decision-making model. Fulton Elections leaders' unethical behaviors include sexual harassment, retaliation firing, falsifying voter records, voter suppression, disenfranchisement, and failing to abide by an oath of office. The triad of personality traits that mostly affect fraud or unethical behaviors are narcissism, Machiavellianism, and psychopathy. Each behavior involves a different segment of the interactionist ethical decision-making model. In no way does this article suggest or imply a person's diagnosis. Instead, it uses public information to compare election leadership qualities to an interactionist ethical decision-making model. Fulton Elections leader Sam Westmoreland was convicted of 2 DUIs from prescription drugs and falsified his work history to gain employment with Fulton County. Narcissism is an individual's motivation to act unethically for individual gain with the subsequently altered perception of their abilities to commit fraud more than once. Leader Barry Garner pled guilty to sexual harassment. Machiavellianism is an individual's motivation to act unethically, while the individual's perception of deceiving others is considered because of the opportunity it presents for the individual. Psychopathy, on the other hand, involves rationalizing fraudulent behavior. Leaders who justify their actions and excuse themselves from wrongdoings reconcile dishonesty with personal resolve using patterns of destructive, unethical, immoral, or even illegal behaviors coupled with superficial apologies that fail to convey any sense of remorse or regret, and lack sensitivity for the feelings of people they hurt, regardless of the situational or environmental factors. Other reasons for committing fraud identified include social pressures to be perceived as successful, powerful, or affluent, which justifies their actions with intentional lying, cheating, or stealing. This triad of personality traits, using the interactionist perspective for unethical decision making, describes the following causes of these behaviors. There's a motivation, like paying for performance. There's opportunity, maybe more leadership roles. There's a rationalization, which is a deflection or defensive actions. There's self-efficacy, which is you're successful at getting away with it, or you exploit trust. And now this fourth behavior, self-efficacy, it theorizes that a person who commits fraud also believes they can get away with it. Fraud, as a multitude of distinct types of cumulative activities, varies among states, criminal justice agencies, and private institutions, but they all share four elements: the intent to deceive, a falsified statement that is material in nature, knowledge that the statement is untrue, and damage or loss resulting from the deception. Negligence is the breach of an obligation of duty to act with care, or the failure to act as a reasonable and prudent person with duties and obligations. Obligations to act with responsibility can be established in contracts with res ipsa loquitur or as a public duty, but duty of care is a legal obligation which imposes a duty on individuals not to act negligently. Nevertheless, if Fulton election leaders are unwilling to admit their shortcomings relative to ethics modeling or due to a responsibility to morally uphold their obligations of the Constitution or their oath of office, how can they define or live up to ethics? What is the base form which they will grow? How can these leaders determine if they are operating within the realm of organizational ethics or individual rhetoric? The first step in any business ethics plan is acknowledging as individuals and as a team what needs to change. Who are the stakeholders? What are the organization's social responsibility and obligation to stakeholders? What are the human resource needs apart from stakeholder management? What is the timeline needed to implement and execute duties? The fiduciary responsibility of election leaders is beyond a management plan. Instead, leaders must provide a balanced work environment of diversity, inclusion, and ethics. Leaders should demonstrate moral humility with a propensity to show humility in the context of dealing with the moral issue as a reflection in their willingness to view themselves honestly. Humility is foundational. It's a virtue for other virtues, including morality, believing it to be self-transcendent. Humility is known to dissolve the potential acts of unethical behaviors or excessively inflated egos. Leaders with a moral humility, growth mindset are teachable and learn from past mistakes, while leaders with a fixed or entity theory of growth and humility believe morality levels are unchangeable and innate. Leaders with moral humility are self-efficient, enabling them to honestly and accurately measure their moral competence. These leaders can admit past mistakes and acknowledge any biases that may occur when making decisions regarding stakeholders. Self-efficacy is also positively related to pro-social behaviors, which require an intentional pattern of actions like Kant's shopkeeper model. What's good for business is the right thing to do, no matter what the underlying benefit may be. Elections are a constant state of stakeholder transactions between millions of people, which requires leaders to understand crisis prevention and management from a top-down principle model. As such, it is the responsibility of the Secretary of State to ensure each county director can handle multiple lines of supply chain logistics, unanticipated shifts in operations using project management techniques, extraordinarily intense and stressful environments, showing control, consistency, and enthusiasm when needed, using their self-awareness skills, changing environments that require instantaneous and decisive decision making, transformative leadership strategies that sustain, engage, and retain employees with low turnover rates. And they need to be able to reassess disaster with contingency plans as needed. There needs to be communication with diverse populations using inclusive two-way languages, capable of developing these transformative relationships. Critically essential and constructive feedback to implement and execute an action plan for change using double loop learning theories. Moral or ethical conflicts regarding their integrity without compromising the organization's values. An obligation to a duty of care, a duty of loyalty, and their oath of office. The Secretary of State is responsible for each county director to be able to do all of those things. Election leaders must also be visionary in this technological-driven society. Leaders must be capable of anticipating emergent trends for themselves and their team's roles and responsibilities. For example, instead of relying on never-trained handwriting experts to validate ballot signatures, an innovative leader would secure technology that streamlines the process signature validity process with digital optical readers. These leaders are ultimately responsible for the accountability and oversight of their teams. When a leader uses strategic operations that efficiently provide a system of continual feedback, an auditing loop of capabilities and bottlenecks is created. This double loop feedback system gives opportunities to prevent unethical compromises or illegal acts from happening. Organizational ethics requires innovative operations that provide double loop feedback and flexible, humble, ethical, moral, and authentic leaders. The authenticity to want to do what is right and just is the foundation for a value-based framework of policies and governance. A customized election ethics program should teach employees of potential legal and ethical issues in the workplace. An FCE ethics program should include a code of conduct, an ethics officer to oversee the program, formal training, auditing, enforcement, and revisions as needed. There should also be written acknowledgement of each employee's duty of care and duty of loyalty. The duty of loyalty is essential because it acknowledges an employee's understanding of conflicts of interest. And in the previous example that I gave of Ralph Smith Sr. As a registered agent to his son's company that did the campaign work for, at the time, mayoral candidate Keisha Bottoms. During the investigation, both father and son stated Ralph Smith Sr. was not aware of any of the son's company transactions, nor did the father have any direct financial benefit. Several Fulton County commissioners acknowledged the potential conflict of interest, but the Smiths did not individually believe a conflict of interest existed. According to organization governance, a duty of loyalty states that a person of an organization shall not have any personal gain from the said organization directly or indirectly, unless approved ahead of time through a code of ethics or other regulation. Ethics programming is not merely lecturing or signing an oath. It's a transformative model led by C-level executives. In Georgia elections, the C-level executive or the Secretary of State must create resolve beyond the status quo into an uncommon territory for election logistics to meet President Roosevelt's ideal discussed earlier. The new programs established should be strategic and specific to Fulton elections with clear objectives to deter and detect unethical patterns and behaviors and prevent law violations. Organizational culture explores the circumstances under which administrators blend personal and work values to reach decisions, and how the public sector particularly uses a hierarchical culture of compliance using fact-based decision-making regulations, centralization, manager focus, and the acquisition and application of technical knowledge. The public sector culture that Fulton election leaders should execute needs to be transformative, unbureaucratic, value-laden, and capable of withstanding emergency contingencies. Leaders that acknowledge their values are predecessors to their ethicality can evolve from their personal interests to public good interests. This shift leads to servant leadership. Transitioning from a bureaucracy to a flattened organization decentralizes authority practices, which further develops public interest values. Flattened organizations are considerably more diverse, inclusive, transparent, and performance-driven than bureaucracies. Duty clauses are ethical agreements with the fundamental value of compliance. The employer and the employee's relationship are the first stakeholder agreements and should be defined in compliance regulations. Compliance and explicit written and verbal understanding between employers and employees acknowledges an organization's rules and expectations. Compliance is founded on priorities and values set by the organization. Examples of common values or principles for organizations can include respect, trustworthiness, responsibility, fairness, caring, or citizenship. Social responsibility maximizes an organization's impact on stakeholders. Social responsibility is a progressively emerging trend for organizations to show its commitment to the public good. However, when social responsibility is related to the public sector or government, it's assumed the public's interest is already a priority, with ethical standards inherently implemented and complied with in totality. The first principle of ethical social responsibility with public stakeholders is transparency regarding the use of public funds. Next, the public expects social responsible conduct from elected or appointed leaders and government employees without question to follow the law. These principles related to Fulton elections include: 1. County election statistics should be updated, accurate, and accessible on the county dashboard. 2. Election personnel will be ethical in their use of public funds. 3. County voters will be allowed to vote in politically neutral environments without hassle, according to their constitutional right at every single election. Fulton elections should also develop a civic engagement model to support increased voter turnout to build informed and engaged residents and voters. Informed and engaged voters can decrease problems during the voting process with prior education. Educating employees on Georgia's voting and election history and current legislation regarding voting is critical to reducing issues during the voting process. Voting rights litigation is essential for election officials to understand. Often, discriminatory infrastructures in the election process prohibit minority communities from choosing candidates of their choice. Knowing how to select viable candidates empowers communities, which can also groom new leaders who will share that information in its capacity building efforts. And capacity building exposes a potential for community leaders to learn new skills and maybe even encourage them to become elected officials themselves. In contrast, others are destined to be community organizers or volunteering or working for campaigns, but all of that can go into the civic engagement model. Several ethics theories are used to understand the ethics of elections. Consequentialism and utilitarianism are two forms of normative ethics that considers the right thing to do and what produces the best option for the public good. If election laws are for the people, disenfranchisement is obsolete. In this way, the utilitarian theory is similar to social injustice reform activism, which impacts the most significant number of people at times against the dominant authority's best interests. Duty theory, on the other hand, states nothing can possibly be conceived in the world or even out of it which can be called good without qualification except a good will. Deontologists like Immanuel Kant believe that actions of right or wrong are independent of its consequences. In other words, ethics is the fulfillment of duty to all, regardless of the results when intentions are pure and good. Election laws appear to be a give and take phenomena in American history instead of an outright honest effort to do goodwill for humanity's laws. It is every citizen's right that is of age to have a fair and due process of their concerns. Voters feel deprived when addressing concerns in federal courts because judges typically favor a reluctance to interfere with state legislation and are overly deferential to the states. A new approach to the electoral due process is needed for the integrity of the Constitution and the little man walking into the little booth with a little pencil, making a little cross on a little bit of paper for his voice to be heard. Thus, supporting state legislation election law reform with a new understanding of today and tomorrow's challenges. Milkovich believes that the best way to accomplish election reform is through the federal courts adopting explicit legal standards for election law and due process of electoral claims. Standard operating procedures gave Georgia state workers the ability to wipe electronic voting machine data from its servers in 2017, just after a lawsuit was filed concerning the machine's poor performance. Though policies like these are not formal rules, they impact the challenger's ability to gather evidence that is crucial for making a case about election failures. Concerns over election administration as a matter left to the states must first be adjudicated according to state-provided procedural vehicles. Only once available state remedies are exhausted may a litigant raise constitutional election failure claims in a federal court setting. The Supreme Court is hesitant to rule on matters that may dilute the separation of powers and system of checks and balances. Federal judges prefer election questions to be answered at the executive or legislative branches of government. Nevertheless, when the right to vote is violated, the laws created and enforced by elected officials can no longer be considered an expression of citizens' free choice and self-determination. Further, no right is more precious in a free country than that of having a voice in the election. No other rights even matter if the right to vote is undermined, according to Supreme Court ruling Westbury v. Sanders. Reynolds v. Sims Supreme Court ruling found any alleged infringement of the right of citizens to vote must be carefully and meticulously scrutinized. Reynolds explained that the right to vote encompasses one's right to put a ballot in the box without suppression, destruction, alteration, avoidance, or fraud, and counted fairly in an equally apportioned election district. The court ruled a person's right to vote is not merely the right to cast a vote, but also the right to have a full and effective vote. Thus, when Fulton election practices contribute to the following effects: A citizen's unconstitutional right to vote is violated just as it would be if they were prevented from casting a vote at all, including if it does not deliver absentee ballots to even one voter, changes vote tally records, misplaces ballots, does not allow voters to vote with provisional ballots, does not have working equipment or ballots for people to cast their votes, opening polls later than scheduled voting hours, does not plan for electrical outages, sends voters to the wrong polling location so they aren't able to vote, dumps voter registrations in the trash, poorly and unethically managed election logistics, creating excessive long wait times higher than the national average, configuring ballots with wrong districts, which invalidates a person's right to vote, falsely verifying vote tallies, poll managers allowing campaign material at voting entrances, submitting election results late. These are all things that just cannot happen. The one person, one vote principle even affirms that if a vote is lost due to email or IT complications, lost to a software breach, or malfunction and prevents a voter from participating in democracy, that citizen's constitutional right has been violated. The Supreme Court ruling in Anderson versus Celebrezze found that subjecting every election regulation to strict scrutiny could invalidate large swaths of election codes and chaos would ensue. Thus, laws may require stricter scrutiny and more flexible standards like those given in the Burdick versus Takushi's Supreme Court ruling, which states that the state must be exact in its justifications for and the necessity of a burdensome rule to be balanced against the character and magnitude of the alleged injury to the voter's constitutional rights. State election laws require courts to apply a more rigorous standard of review. The more the law burdens the First and 14th Amendment rights, if a rule places a severe burden on those rights, it must be narrowly drawn to advance the state's interests of compelling importance. If a rule only restricts those rights in a reasonable and non-discriminatory way, then important regulatory interests are usually enough to justify the rule. For example, Milkovich states voter confusion and ballot overcrowding is a reasonable restriction. Simultaneously, faulty voting machines that prevent a person from voting are a severe burden to the law or severe vote deprivation that is not justified by a state's interest to save money, time, or administrative effort. Fulton elections should be concerned with the Due Process Clause, which requires states to exhaust all remedies to prevent vote deprivation during elections. Suppose it is found that Georgia has an election administration problem in Fulton County, with an enormity of failures that are not resolved after corrective action, and there is continual disenfranchisement. In a case like this, the federal courts can intervene for patent and fundamental unfairness when the state's corrective processes are deemed inadequate, according to U.S. Court of Appeals Griffin versus Burns. The due process election claims in Hennings versus Grafton, Pettingill versus Putnam, and Shannon versus Jacobowitz all ruled that federal courts should not hear a procedural due process claim unless it alleges intentional government wrongdoing first. Specifically, state or county officials purposely, systematically, or willfully acted to deprive voters of their liberty interests in a meaningfully executed vote. The lack of ethical leadership or void in transparency evolves into a violation of another person's constitutional rights. Is moral humility enough to offset potential unethical behaviors? Does violating one's oath of office as a public election official warrant an investigation? Do Fulton election leadership practices related to disenfranchisement and potential abandonment of duties per the Constitution, does that equal criminal behavior? U.S. service members must earnestly discuss notions of ethics and values throughout their professional careers, promulgating and aspiring to certain core values such as integrity, service, excellence, obedience, and honor. George Washington required all officers to pledge allegiance to the United States in the first official oath during the American Revolution. The oaths of office are described in Articles 2 and 6 of the Constitution and statutes enacted by Congress and state legislators. The first official act of the First Congress of the United States established the oath, "I do solemnly swear or affirm that I will support the Constitution of the United States." Furthermore, during the Civil War in 1861, President Abraham Lincoln required all federal executive branch employees to swear unto an expanded oath of office in support of the Union. On July 2, 1862, Congress enacted the test oath, which added a requirement for persons elected or appointed to swear or affirm their behaviors. Additionally, some oaths require mandates that support the U.S. Constitution and respective state constitutions. On July 4, 1776, the Declaration of Independence created America's fundamental principles of republican or constitutional government principles and required all Americans to swear to uphold the Constitution as the supreme law of the land, serving at the will and by the consent of the people. This supremacy clause is a conflict of laws rule specifying that certain national laws take priority over any state laws that conflict with the national law. The oath of office is more than a mere promise. It is a morally binding commitment to upholding the Constitution. Moreover, it's a statement of professional independence rather than subservience, exposing administrators to the constitutionality enduring values, which they must uphold. It also defined as a regulative code of ethics that provides guidance on where the ethical boundaries of one's practice can be found. Election officials carry out constitutional duties laden in constitutional values that coexist with their managerial, ethical, and political beliefs. The virtues that leaders should encompass are honesty, consistency, coherence, reciprocity, civic integrity or stewardship, promoting human rights, and contributing to the policy community. Further, election administrators should be disciples of the rules of law, which are legitimated, legislative-centered, judicially proven, and conferred on to them as a sworn officer of oath within a democratic system capable of exercising judgment and discipline in the governance process. In direct conflict to this idealism is the opinion that public administrators are civil servants who are lazy, incompetent, formalistic pencil pushers who are only interested in advancing their leadership powers. Although untrue and a subjective statement, we must take into account that Barron's influence on policy implementation as a middle manager compared to top civil executive servants like the Secretary of State is far more significant and impactful at the voting level. These bureaucratic hierarchies in government are no longer adequate with the expansion of government, which places public administrators in this difficult position of choosing among conflicting values in the interpretation of ultimate policy. The expansion of administrative tasks outnumbers policies that elected officials have successfully voted on. Thus, like Barron, middle managers must fill in these gaps with expertise in operations management. Daily implementation strategies have become unconfirmed policies similar to Ralph Smith's testimony. Without rules and regulations for pertinent civil and constitutional rights, civil servants become inadvertent policymakers, taking the task away from those that were elected to make those decisions. Legislators pass general laws, leaving it to the appropriate executive departments to construct the specific regulations by which the law is actually implemented. Citizens who find themselves afoul of the taxing authority may ask to be shown by what authority they are being charged, but they will then be referred not to a statute, but to a small passage in a large volume of regulations written by civil servants and not lawmakers. Protection of the people's liberties from the arbitrary exercise of official authority requires as much or more attention to the pedestrian activities of minor officials than to the majestic proceedings of a Congress per se. Incidentally, this is why the oath of office is a vital part of democracy, and choosing capable leadership is priceless. As recorded in Schiff versus Gwinnett County, county defendants are required under Georgia law to appropriate annually to the election superintendent the funds that it shall deem necessary for the conduct of primaries and elections. Similarly, Fulton County defendants are charged under Georgia law with the responsibility of administering the elections, which includes selecting and equipping polling places, hiring and training poll workers, purchasing voting supplies other than the machines, and processing and implementing voter registration and absentee ballot procedures. Our democracy is figurative, with the clear separation of powers between the three branches of government. It allows federalism and free market economies to be in synergy with another, which prayerfully would encourage public leaders to be efficient and effective with taxpayer dollars, support the public's right to know about what public organizations are doing to and for citizens, and promoting the public's right to be involved in the governance of the state and the nation. Fulton County's past three initiatives, 2017 through 2019, are found on its website. It is unclear whether these objectives were met or in what capacity the funding was allocated. As a public agency, the corresponding financials should be readily available and accessible to the public. The current initiatives related to this study, beginning with 2017, include they adopted new customer service standards and policies, unclear if elections was included, invested $100 million in facilities and improvements, unclear if Fulton elections was included, and they completed $6 million in IT improvements. Again, it's unclear if Fulton elections was included. 2018 initiatives. They implemented a pay-for-performance plan with a primary focus on customer satisfaction and critical department metrics. Unclear if Fulton elections was included, but for ethics, pay for performance is never a good idea. They continue to use new HR policies to support crucial talent development and retention. They delivered new website experiences and target self-service customer capabilities. Utilize performance reporting at the strategic and department levels to drive performance-oriented culture and transparency, and developed an intense focus on the three core processes related to criminal justice, elections, and property tax, and managed effectively through metrics and process management. Again, all of these are unclear if Fulton County elections was specifically involved. They invested $7 million in election process to ensure performance in the statewide election cycle. And they continue to invest $100 million in capital programs for facilities and improvements. Continue to invest $25 million in the information technology roadmap implementation. And lastly, in 2019, they do not have their 2020 initiatives up, although we are at the end of 2020. So that would be important to say what your initiatives are so the public knows what you're working on at the time, not after the fact. But in 2019, they wanted to complete phase 2 of a planning and emergency preparedness plan. They continue to invest $100 million in capital programs for facilities and improvements, and continue a $25 million investment in the information technology roadmap implementation. Again, it does not say anything about how exactly these were measured. Poll workers on their website have a 95 to 100% customer satisfaction rate. I would ask Fulton County residents, do you think this is true or false? Another recommendation for Fulton elections is complete transparency. Fulton Elections is currently not reporting its administrative election statistics on the Fulton County Strategic Performance Platform. As an example, current Fulton County statistics across departments are shown below, and these are reported as of January 2020. 99% customers indicate that their expectations were met when receiving service from the state court in Fulton County. It is unclear how many responses were collected or the total number of actual customer care experiences to really validate the significance. That should be on the website. 96% of outcomes indicate that expectations were met when receiving service from the Fulton County Attorney's Office. Same validity questions are not apparent. There was a 100% of voter applications processed within 30 business days, excluding blackout periods. Validity, unclear. Is it 100% because only one person asked? Was the person a Fulton Elections employee? Just unsure, but it's 100% voter applications processed. They unfortunately were not able to keep up with their 100% percentage rates during the election June 2020. There was a 24% of sworn police officers participated in yearly mandated training. The validity is not important, but the important piece to this is the police officers are reporting a 24% rate, which is low, but in case of ethics, it's far better to be truthful than not truthful. And lastly, it looks like Fulton County elections had a 0 voter education events. Their countywide initiatives are at 50%. And again, there is truth to telling the truth instead of falsifying outcomes. Here you can see the 100% service record. And this brings up a good point of the pay for performance. Are you willing to lie to say you're doing one thing so you can get a bonus? Election auditing, compliance, and satisfaction, no data. Now, what can Fulton County elections do today? They need to immediately hire a consultant to help them problem solve their organizational processes. Although it is more cost effective to train current employees than hire new employees, staff that are fundamentally unethical or found probable to be a direct cause of voter disenfranchisement, they must be fired or placed in positions that do not directly impact violations to a person's constitutional rights. In these cases, Fulton County will find it more costly to keep these employees if they do, and possibly have the county be sued. Secondly, Fulton County must identify and purge all conflicts of interest within its human resource infrastructure, starting with county commissioners. Next, Fulton Elections must be honest with its self-reflection, dashboard statistics, and audits, and they should consider its pay-for-performance policy, which deters accurate reporting of public interest and increases an employee's propensity to participate in unethical practices by forging false reports. Currently, Fulton County Board of Commissioners offers monetary awards to reward employees for their performance of contributions towards achieving established operational objectives, goals, or performance targets, but without detailed auditing or dashboard reporting. Recommendations for an initial framework for the State Board of Elections to consider would be intentional hiring practices with strategic human resource management initiatives, developing a model of workplace ethics with diverse and inclusive principles, identifying stakeholders for social responsibility programming, creating a policy and procedures manual explicitly for Fulton Elections, including their own departmental mission, vision, and values, quarterly training, performance measurements, community outreach. And lastly, the Fulton County Elections website should be user-friendly, interactive, and customer engaged. Constituents should be able to see who the staff members are and their job roles and responsibilities. The website should also include accurate information about how to contact staff regarding frequently asked questions, and the website should be a designation for voting resources that complements references to the Secretary of State and the Georgia General Assembly platforms. I truly appreciate you spending this time with me on this analysis of ethics in Fulton County, starting with the historical analysis. The following slides are reference slides, and I look forward to any discussion as a result of this project. I appreciate you immensely. Thank you so much. My name is Mesha Mainor. I am the state representative for District 56 in Georgia's beautiful Fulton County.